realized that it had made a massive error, because in so doing, it came up against a major difficulty, that of evidence for the alleged facts and its application in its entirety. And in order to overcome that obstacle, it tries to broaden the scope of the Convention and get off with just a few allegations of racial discrimination. Madam President, I think that I've demonstrated the criteria that have to be met by Ukraine in order to prove the existence of any systematic campaign of racial discrimination. Very briefly, let me run through the criteria. The alleged acts have, of course, to be attributable to the Russian Federation. The alleged acts have each to constitute a violation of the Convention. In other words, a distinction, exclusion, restriction, or preference based on race or ethnic origin within the meaning of the Convention, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on equal footing of human rights and fundamental freedoms, and which has no objective nor reasonable justification. Thirdly, the alleged acts have to be part of a systematic campaign or policy. I've also added that there are certain specific conditions that have to be met for the alleged conduct by Russia to be considered as a systematic campaign. We note that Ukraine has not challenged this, but according to Ukraine, it would be possible mechanically to accumulate the unfounded allegations in support of its application, which, to my mind, is untenable. What is more, Ukraine continues to assert that it has no obligation to prove discriminatory intent on the part of Russia. Aside from the question of seeing or finding out how a state could carry out a systematic campaign of racial discrimination unwittingly, for which it would be so difficult to prove the existence of such an intent if, according to Ukraine, and I quote them, there were to be tens of thousands of victims of any such alleged systematic campaign. And Russia would allegedly have targeted the Tatar and Ukrainian communities. Citing these sort of allegations with nothing more than that, does that make it necessarily a systematic campaign? This brings me now to my point concerning the required standard of proof. Ukraine's accusation is exceptionally grave, comparable, as I said the other day, to acts of Nazi Germany or the apartheid regime in South Africa. We note that Council for Ukraine has made no observation on that point. In view of the exceptional gravity, our opponent's accusation has to be proved, according to your jurisprudence, and I quote, by conclusive evidence. Ukraine is trying to persuade you that a standard of proof to be applied should be different in the case of Russia. It refers, as regards Russia, to a standard of proof that's duly established or sufficient evidence or conclusive evidence. It also refers to the Corfu Channel case and says that it should be allowed to have more liberal recourse to inferences of fact and circumstantial evidence. And in so doing, it bases itself on an alleged absence of access to Crimea. Ukraine insists on this point, and that confirms that it has not met its obligations in terms of evidence, nor does it quote the judgment of the court, as it should have done, because it's been ruled that indirect evidence is particularly compelling when it's based on a series of facts which logically lead to the same conclusion. Obviously, even circumstantial evidence requires a very high standard of proof, always. Far from Ukraine to have demonstrated the existence of a systematic campaign of racial discrimination, even on the basis of this standard. What is more, the argument according to which Ukraine allegedly has no access to Crimea is irrelevant in this instance because the statistical data is publicly available. Ukraine, however, chooses to overlook this. It should be underlined that the court has indicated in similar circumstances that, and I quote, in respect of the applicant's claim that the respondent has breached its undertakings to prevent genocide and to punish and extradite persons charged with genocide, the court requires proof at a high level of certainty appropriate to the seriousness of the allegation." End of quotation. It is worth recalling here as well that this question, on this question in Croatia versus Serbia, the court considered the possibility of acknowledging indirect proof of an intention to commit genocide by way of deduction. It necessarily requires that such a conclusion is the only one that could be deduced from the acts at issue. A final observation concerning the administration is necessary. As we noted last Thursday, Ukraine seems to attach considerable weight to certain reports by the United Nations High Commissioner for Human Rights. However, information concerning Crimea that have been produced by the High Commissariat are almost exclusively, and I underscore this, almost exclusively based on data provided by NGOs that are sponsored by the United States and certain European governments. These reports in themselves, therefore, cannot be used as sufficient evidence, and certainly not conclusive evidence, in order to establish Ukraine's allegations. This brings me to the importance of statistical data. As regards the question of the importance of statistical data, Ukraine states that statistical data is not necessary in all cases of allegations of racial discrimination. Russia has already demonstrated that this approach is erroneous, nor is it reasonable, particularly in this particular case, in other words, in an alleged case of systematic campaigns of racial discrimination. In any case, statistical data is in the file. Russia has produced ample statistics, but Ukraine is asking quite simply to overlook them and follow, according to it, a certain common sense approach. Of course, it goes without saying that there is no sense to be attached to this. According to common sense, if statistical data is used, it should be used in order to avoid there being any speculation. If Russia were really carrying out a systematic campaign of racial discrimination, this would necessarily be proved by the statistical data, but that is not the case here. The statistics provided by Russia show, once again, that there was no abnormal situation in Crimea as compared to what you see in other regions of Russia. If Ukraine's accusation were to be plausible, the facts and figures, for example, concerning disappearances of individuals and extremist offences would be far higher. Without statistical data and without any discriminatory legislation in Russia, we cannot see on what basis Ukraine contends that entire communities are allegedly being targeted by the Russian government in order to erase them, and that allegedly there's some state plan or policy in this regard. By denying the importance of making any comparison in order to come up with proof of a differentiated treatment, Ukraine is insinuating that any measure directed at an individual of a given ethnic origin would ipso facto be racial discrimination. But that is quite clearly untenable. Demonstrating a different treatment of an individual, or in this case of a particular community, comparing it with another, on the basis of grounds banned under CERD, is essential if we're to prove that there's been any racial discrimination. Such differentiated treatment does not exist in Russia as regards the Tatar and Ukrainian communities. Madam President, members of the court, as you heard on Monday, Ukraine argues furthermore that Russia misinterprets CERD, particularly as regards the notion of discrimination by effect and the supposed indirect discrimination. Ukraine's arguments must be dismissed for several reasons. First of all, I have to clarify that, contrary to what our opponents have argued, Russia in no way denies that racial discrimination by effect would be a violation, a breach of the Convention. But it should be recalled that here, this is not the request that was acknowledged in your ruling of 2019, and that all relevant elements are to be found in Article 1, Paragraph 1 of CERD, even if Ukraine is attempting to give a partial interpretation thereof. You see the paragraph of this article on your screen. Russia's interpretation of what makes up racial discrimination fully complies with all of these conditions. Ukraine's position presents a major drawback. It seeks to eliminate differentiated treatment, which is a fundamental element of the definition of racial discrimination. It attempts to eliminate it from the text of the treaty. In other words, for Ukraine, there may be racial discrimination even if there's no distinction, exclusion, restriction or preference establishing a hierarchy between social groups. This attempt to rewrite Article 1, we have understood, is necessary if Ukraine's arguments, if one of Ukraine's arguments is to succeed, in other words, that of indirect discrimination. According to our opponents, indirect discrimination is included under the term discrimination by effect. On Monday, one of the Council for Ukraine described the so-called indirect discrimination in the following way, where a facially neutral measure gives rise to an unjustifiable disparate impact along racial or ethnic lines. And Ukraine is basing this primarily on the Fredman report. This notion of indirect discrimination is in no way compatible with the definition of racial discrimination that I have just explained to you. The third requires a distinction, exclusion, restriction, or preference. Without this different treatment on the basis of race or ethnic origin, there is quite simply no racial discrimination within the meaning of the Convention. Recommendation 14 of the Third Committee clearly confirmed this, and I quote, when it noted that different treatment is not an act of discrimination if, compared to the object and purpose of the Convention, the differentiation criteria are legitimate.
Ukraine, however, considers that different treatment could be and lead to an unjustifiable disproportionate effect. Now, this has never been explained, or its meaning has never been explained in our opponent's pleading. When can you say that an effect is disproportionate or unjustifiable? How can this fit in with the need to show that there would be distinction, exclusion, restriction or preference, which would have as its purpose or effect to destroy or limit the human rights of one social group compared to another? In fact, Ukraine is not referring to some kind of disproportionate impact, but to equal result, which is in fact not foreseen by the Convention. To support this, Ukraine also relies on the opinion of Professor Friedman, according to whom the indirect discrimination or disparate impact focuses on inequality of result rather than inequality of treatment. But this, I'm sure you will recognize, is not known to the Convention. Russia has shown quite clearly and convincingly that differentiated treatment is the sine qua non to establish any discrimination, racial discrimination. In fact, the Convention expressly requires it. The Third Committee in Recommendation 14 clearly states it too. The Court has also confirmed that indirect discrimination as defined by Ukraine, does not come into the scope of the Convention. In its 2021 ruling in the Qatar 2 versus UAE case, the court ruled that while the measures based on current Qatari nationality may have collateral or secondary effects on persons born in Qatar or of Qatari parents, or on family members of Qatari citizens residing in the UAE, this does not constitute racial discrimination within the meaning of the Convention. In the Court's view, the various measures of which Qatar complains do not, either by their purpose or by their effect, give rise to racial discriminations against Qataris as a distinct social group. There is no reason why the court should diverge from its established case law. The measures taken by the Russian authorities, taken, for instance, on the basis of illegal extreme acts committed by some individuals, may, of course, lead to collateral or secondary effects on persons of Tatar or Ukrainian descent. In fact, on people of any racial or ethnic descent. But that does not constitute racial discrimination under CERD. This does not give rise either to their in their purpose or their effect to racial discrimination against Tatar or Ukrainian communities on the basis of their ethnic origin. Ukraine also refers to the consultative opinion on minority schools in Albania. To convince you that this opinion on inequality in fact is analogous to the reference inserted of the disparate effect of an apparently equal treatment. But that is not the case. In fact, the consultative opinion clearly shows that equality does not concern non-discrimination, but in fact a balance or equilibrium, notions which are not covered by the convention. And that's all you can say. Here, equality in law precludes discrimination of any kind, whereas equality in fact may involve the necessity of different treatment in order to attain a result which establishes an equilibrium between different situations. As concerns, Madam President, of now the supposedly discriminatory acts, what you need to understand is that Ukraine is no longer denying the obvious, at least as concerns discrimination by effect, including indirect discrimination. The acts of a state may well be justified and thus would not constitute racial discrimination under the Convention. In fact, Ukraine now states, in contradiction with its initial claim of an alleged systematic campaign of racial discrimination, it claims that its allegations rely on an alleged discrimination by effect, meaning that the measures taken by the Russian authorities may therefore be justified and be compatible with a convention. Now, it's also worth noting a significant particularity in the strategy of Ukraine. Even though it admits, as concerns discrimination by effect, that justification may be possible. At the same time, Ukraine states that the purpose to discriminate may be derived by inference only of the disproportionate effects of a measure. Now, with this argument, Ukraine seems to want to deprive states, or Russia in this case, of the opportunity to justify its objective conduct. And this would include carry a number of significant risks insofar as a measure taken by a state with the slightest effect on a minority or a single member of a minority in any field whatsoever should be considered as discriminatory and therefore in breach of the Convention. States would therefore be unable to take any necessary measures to ensure law and order or guarantee national security, lest it breach the Convention. And this absurd argument cannot be upheld by your jurisdiction. How can a state justify a measure? Let me refer you back to recommendation 14 of the committee. As you can see it up on the screen, I won't read it out entirely. It is very well known. Let me just, however, make a few comments in this respect. First of all, Ukraine has on a number of occasions accused Russia of wanting to consider the validity of its measures as being self-judging. Now, this is inaccurate. Every measure taken by the bodies of the Russian Federation come under the scrutiny of the Russian legal system, including the judiciary. Moreover, it should be noted that Russia has submitted to the jurisdiction of your court. Russia has absolutely nothing to hide. Secondly, one of the counsels for Ukraine also mentioned the tests that should be applied by the court to determine whether measures taken by the Russian authorities are justified. He noted that the committee gave no guidelines and that maybe we could refer to and rely on the opinions of the Human Rights Committee. Now, as concerns the committee, its practice shows that its justification for all sorts of very varied measure rely on various items. For instance, look at employment-related discrimination, which is one of the main body of opinions covered. In this context, issues relating to skills and competences of applicants may be seen to be discriminatory in an initial phase. Now, as concerns the Committee on Human Rights, Ukraine refers to observations number 27 and 37, focusing on the right of freedom of movement and the right to peaceful assembly. These do not deal with justifications in terms of racial discrimination. These observations, however, explain that exercising such right may be restricted to protect national security, law and order, public health, public morality, and the rights and freedoms of others. These restrictions must, in fact, be set forth in the law and must be necessary in a democratic society to protect the stated goals and must be compatible with all the other rights recognized in the covenant. Legal practice, as adopted by Russia, is entirely compatible with the rules covered in various multinational instruments. These instruments recognize rights such as freedom of expression, freedom of conscience, of religion, of opinion, and at the same time they consider the possibility of imposing legitimate restrictions as set forth in law. It is clear and obvious that the states parties to the convention could never have decided any other way, as Ukraine also recognizes. Now, the fight against extremism and terrorism is a crucial priority for Russia, as is the case for many other countries. Law and order related actions in this respect are absolutely not exceptions to the absolute prohibition of racial discrimination. These measures apply to anyone suspected of extremist activities. Race or ethnicity plays no role in this. Russian legislation itself considers that some aggravating circumstances in these instances would be racial, ethnic, political, ideological or religious motivations. Whatever the criterion applicable, the measures taken by the Russian authorities are justified in this instance. Russia has given reasonable and objective explanations for each of the measures at hand. Ukraine, on its part, has only banded vague accusations against the legal system in Russia and its anti-extremist legislation. Ukraine, as the applicant, has to prove that each of the measures taken by Russia is not justifiable under CERD. It has not done so, and years of proceedings have now shown that Ukraine cannot do so. As concerns the fight against extremism, and councils for Ukraine discussed this on Monday. Let me make a few brief comments. Professor Hadi Azari will revisit this issue in a moment. Ukraine is asking your court to consider that Russian laws are being applied abusively with the sole purpose of targeting Tatar and Ukrainian communities in Crimea. But there again, Ukraine has not proved anything. Our opponents want you to speculate, to consider that the Russian legislation is necessarily suspect, that you should draw a conclusion, a general conclusion for the entire body of law. And for Ukraine's allegation to hold, Ukraine would had to show that on an individual basis, the Russian law had indeed been abusively applied and created specific harm to the Tatar and Ukrainian communities. In its rejoinder and through the work of experts, Russia has shown that its anti-extremist legislation was adopted well before the reunification of Crimea with Russia. To support its accusations, Ukraine relies on an improper interpretation of the 2012 opinion of the Venice Convention and other statements made by the CERD committee. As Mr. Engel has shown, the Venice Commission nowhere states in its report that the Russian legislation is discriminatory towards racial or ethnic minorities. On the contrary, the Commission has recognized the legitimate efforts of the Russian authorities to fight against extremism and related threats. The Venice Commission, has indeed, in other places, mentioned its concern as concerns the challenges related to the fight against extremism, including in its most recent forms. Mr. Engel has also stressed that the Venice Commission refers to the Shanghai Convention on Combating Terrorism, Separatism and Extremism, but it does not consider the 2017 Shanghai Organization's Convention for the Cooperation in the Fight Against Extremism. Lastly, as concerns the third committee, Professor Aftanomov has explained that the committee describes the legal definition of extremist activities in broad and imprecise terms, but he has never suggested that the anti-extremist legislation in Russia should be repealed. What is important is that the committee has never determined that the Russian legislation would be discriminatory against Tatar and Ukrainian communities. Let us note that according to the statistical data, the extremist activities are not significant in Crimea. Over 2014-2022, the number of extremist offences in Crimea was 1.5% of the overall infractions and offences in Russia. Only 161 offences have been registered over 9 years, compared to 10,640 for the whole of Russia. 100 individuals have been prosecuted for extremist offences in Crimea, 1.3% of the total number of people detained over 2014-2022, or 0.005% of the entire population of the region. Let me lastly mention the real aim of Ukraine in this case. And clearly, as you have heard over the course of the hearings, its aim is undoubtedly to discuss before your court of the status of Crimea, an issue that does not come under your jurisdiction. This is highlighted by two things. First of all, Ukraine is still insisting on the fact that political opinion would be relevant to establish ethnicity. As we have shown last week, this is entirely incompatible with your ruling in the Qatar against UAE. Indeed, the court observed that the definition of racial discrimination in the Convention includes national or ethnic origin. These references to origin denote, respectively, a person's bond to a national or ethnic group at birth. There's therefore no doubt ethnicity is a trait acquired at birth. All the efforts made by Ukraine to convince you to drop your case law is in vain. The political aim of Ukraine also transpires in the wording used. For instance, a collective punishment for their principled opposition to Russia's perpetrated annexation of Crimea, or a policy on Russia's part of neutralizing those voices capable of providing the Crimean Tatar and Ukrainian communities with political and intellectual leadership. Or those acts should be treated as discriminatory measures designed to force the ethnic groups into submission to Russian occupiers, not crimes committed against individuals for political reasons. So, as Russia has shown, the aim of Ukraine is indeed to discuss the status of Crimea. Let me just say that the ruling on the merits that the court will render in this case will apply and cover only the legal dispute that has been submitted, not political considerations. I can say that not one of the 182 states parties to the convention would ever agree to this very use, very remote from the object and purpose of the convention that Ukraine has attempted to put it to. The simple reason being that it would be Ukraine's will. Madam President, members of the court, I have come to the end of this presentation. Can I ask you to kindly give the floor to Professor Hadi Azari?
I thank Professor Shikaya, and I now give the floor to Professor Hadi Azari. You have the floor, Professor.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam President. Madam President, I shall now turn to Ukraine's allegation concerning the Mejlis. In its written submissions, the Russian Federation has duly described to you the real nature of that organization. It's based in Kiev, financed by Kiev, made up of 9 individuals living in Kiev who, with the support of Kiev, are self-proclaimed representatives of the Crimean Tatar community, of the Crimea in Russia. The time has now come for you to have a full image of what the Mejlis is as these proceedings are nearing their conclusion. Ukraine would have you believe in its false narrative according to which Russia has been oppressing the Crimean Tatar community and has targeted a peaceful representative body. That is incorrect. Russia has presented a number of testimonies from Crimean Tatars, including from former members of the Mejlis, which explain that the Mejlis was heavily involved in corruption, chaos and violence. They also show that the Mejlis did not represent the Crimean Tatar community. In 2014, its approval ratings didn't even get as high as 20%. Indeed, the Mejlis has done nothing to settle the problem of the mistreated Crimean Tatar community that it suffered under Ukrainian domination. In reality, the Crimean Tatars are well represented at all levels. There are over 30 organizations that represent some 30,000 Crimean Tatars. The Crimean Tatars are also represented in the elected bodies. In 2019, there were hundreds of them who were elected deputies. The Crimean Tatar Council is made up of eminent representatives of the Crimean Tatar community. There is also the Council for Inter-Ethnic and Interfaith Relations in Crimea, and what is more, a Council for Inter-Ethnic Relations that comes under the aegis of the Russian president. So Crimean Tatars are broadly represented in all of those bodies. Madam President, even if the Mejlis has enjoyed a certain amount of support at the outset, this was lost over the course of time when it embarked upon criminal and extremist activities. The entire history of the Mejlis has been marked by violence and provocation. In 1992, the Crimea was shaken by violent riots organized by the Mejlis. The leader of the Mejlis, Mustafa Dzhemilev, called for a massive mobilization of Crimean Tatars and the establishment of self-defense units, and he threatened to block the railways. As a consequence, the activities of the Mejlis were deemed to be unconstitutional, and that was decreed by the Ukraine itself in 1992. Over the course of time, the Mejlis and its leaders have never chosen to go down the avenue of peace and dialogue, but only issued ultimatums and embarked upon acts of violence. In this regard, I would respectfully refer you to paragraphs 144 to 167 of the Counter Memorial to see the detail of those events that occurred during the Ukrainian period of Crimea's history. In 2014, the Crimean Tatar Assembly, the Kurultai, decided to cooperate with the Russian authorities. The Mejlis, the function of which was to implement that decision, chose to ignore it. Ukraine itself stressed the vital importance of the Kurultai in its oral arguments on Monday, and it didn't challenge the fact that the Kurultai is not banned in Russia. Ukraine claims that Mejlis has been banned in order to target the Crimean Tatar community and deprive it of its political leadership, a sort of revenge, if you like, for its refusal to bend the knee before Russia. Even though this is an absurd assertion, it has at least the merit of showing that Ukraine does not believe that the ban of the Mejlis was decided on racial grounds. Even if Ukraine's far-fetched position were to be believed, this would be a question of politics and not of ethnicity. In reality, Ukraine does not take account of the overwhelming evidence that shows the real reasons for the decision to ban Mejlis. I'd like to cite a couple of cases, but there are a lot of others as well. These two cases are particularly relevant because they are at the very root of the legal decisions concerning the ban of the Mejlis. On the 3rd of May 2014, the Mejlis supporters attacked a border post at Armyansk in order to try to enter Crimea, using force against the border service officials. In 2015, there was the blockade of Crimea. Last week, I showed you some photographs of this blockade. Ukraine remained totally silent on this on Monday. The 2015 blockade was the inspiration of the Mejlis, and it was implemented by the Mejlis members, soon to be joined by the right sector neo-Nazi organization. Mr. Chobarov never denied that he's one of the brains behind it. Mr. Lenor Islamov, who's a close ally of the Mejlis, even referred to it in terms, using the term jihad. Those behind the blockade acknowledged that they had created a humanitarian catastrophe in Crimea. There was the energy blockade, but water supplies to Crimea were blockaded as well. That was the water blockade. They prevented transport vehicles from entering Crimean territory. That was the transport blockade. There was also a trade blockade that prevented the delivery of certain goods to Crimea. Let me also underscore that the energy blockade occurred in the month of November, when it was cold. Ukraine had not supplied gas to numerous Tatar households in Crimea, and people were frozen to the marrow. How can the Mejlis claim to represent the Crimean Tatars having done that to them? That is why in 2016, 5 Crimean Tatar organizations asked the Mejlis to explain itself. Madam President, that is the reason why the Mejlis was banned. There's absolutely no question of ethnicity that came into that decision. In the eyes of any reasonable person, it was extremism. Ukraine finds no further evidence for its allegation that the Mejlis ban was a breach of CERD. It was even pointed out that there was the anti-extremist law in 2016 that was the very basis for the ban on Mejlis. On Monday, Professor Coe asserted that far from justifying Russia's attempt to discriminate in the face of non-derogable norms, its national security law constitutes compelling evidence of Russia's discriminatory purpose as applied to Crimea. And in support of that erroneous statement, he relies on a statement taken out of context to say that certain international bodies stated that that law was vague and broad. Mr. Chikaya has shown that this assertion is unfounded. And for my part, I would add that this statement in no way concerns the ban of the Mejlis. Madam President, the list of extremist organizations that are banned in Russia has some 101 entries, of which 77 are pseudo-religious or Russian pseudo-nationalist. In 2016, 14 organizations were added to the list, including the Mejlis. These organizations share nothing, and there's no racial element in the addition that was made. Under Article 15, Paragraph 3 of the anti-extremist law of Russia, the Mejlis could and should have declared that it was against the extremist activities and declarations of its leaders, denying, in other words, all responsibility. The Mejlis did not do so. So, under the same law, it was deemed to be in support. And a decision was taken, legally founded, to ban it. By way of conclusion, I'd like to draw your attention to one last thing. Madam President, members of the court, before the hearing on the 5th of June, Mr. Chubarov posted something offensive on Facebook aimed at the Crimean Tatars, who are part of the Russian delegation, and you can see this on your screen. Is it worthy of the title representative? Madam President, members of the court, This brings me to the end of what I wanted to say about the Mejlis, and I'm now going to move on to education in Crimea.
As concerns this issue of education, Russia is putting forward figures, statistics, detailed statements, specific examples to confirm one simple fact. Education in Tatar and Ukrainian languages in Crimea is fully available. Tatar and Ukrainian language schools are operational and operating in Crimea. New textbooks are being printed, teachers in these mother tongues are being trained in Crimean universities. Ukraine has not disproved this, and after 2 rounds of pleadings, Ukraine has not given any convincing evidence that pupils, Crimean Tatars and Ukrainians, are denied any education in their mother tongue and are treated any differently from other ethnic groups. Ukraine says that the Russian Federation misinterpreted Ukraine's claim on education. Again, Monday, the Council for Ukraine has claimed that Ukraine has never argued that there is a general right to education in a minority language in Serb. Ladies and gentlemen, this is your summary on the claim of Ukraine on education as you stated it in your order. And it says here, Ukraine further states that Article 5E5 of CERD provides for a broad right to education and training, which also covers the right to be educated in one's own native language. Now, if you go along with the statement made any number of times by Ukraine since the order was handed down, then this claim has been abandoned by Ukraine. So what still stands? According to Council for Ukraine, and I'll quote in English, it is sufficient to establish discrimination in violation of the CERD that Russia removed provision for existing minority language education from some ethnic groups and not from others. The Ukrainian claim has now shrunk to some vague and imprecise allegation, according to which Russia had removed educational resources that used to exist in Ukraine previously. But what were these educational resources in Ukraine, or in Crimea more specifically, before 2014? Look at the Crimean Tatar language. In its pleadings, Ukraine considers that Russia has erased the Crimean Tatar and Ukrainian languages from Crimea's schools. However, it has not at all looked at the issue of teaching and education in Crimean Tatar language, and for a good reason. First of all, the data submitted by the Russian Federation shows a general drop in the number of students and pupils studying in Crimean Tatar before 2014. As you can see it here, there are now more pupils than ever studying the Crimean Tatar language. Moreover, the witness for Ukraine, Yulia Tyshenko, also confirms that the Crimean Tatar has never really been an educational language in Ukraine. According to her, Crimean Tatar language was only studied as a separate subject. The normal languages of education were Russian and Ukrainian. The conclusion is therefore straightforward. Russia had nothing to remove, no resources to remove. As you can see here, you have photos from school number 44 from Simferopol, which teaches in Crimean Tatar. Local residents call it the Four Presidents School because it was started, or the works to build it started in 1993, and 4 Ukrainian presidents never brought it to a close. Russia has spent 430 million rubles, that is some $7 million, to build that school. There are all sorts of educational activities that are also conducted in schools across Crimea to promote the Crimean Tatar language and culture. Since And after 2014, the Crimean Tatar schools were, in fact, teaching in Ukrainian. Look at the school number 20 in Theodosia, for instance, and the high school in Simferopol. The Russian Federation added to its counter-memorial and to its rejoinder a number of testimonies from staff in these schools and other witnesses. These show that schools in Crimea have the full possibility and are free to educate and teach in Ukrainian. Some indeed do so, but fewer and fewer parents see any relevance and interest in having their children study Ukrainian. The drop in the interest for Ukrainian in Crimea is related to a number of objective reasons, each of which has been explained in detail in Russia's writings. First of all, despite the attempts by the Ukrainian government to Ukrainize the peninsula, Ukrainian language was still unpopular and was only really necessary for those who wanted to have a career in the civil service or in the military, for which knowledge of the Ukrainian language was vital. Following the reunification of Crimea with the Russian Federation, this is no longer the case, and the number of pupils studying in Russian is back at its pre-Ukrainization level. Now re-establishes a balance between the natural needs in education in the peninsula, and this is fully covered by the current educational system. Secondly, since 2014, Crimean pupils now have far more opportunities to join and study in Russian universities, which international rankings show are more prestigious than Ukrainian universities. Thirdly, the Ukrainian authorities themselves have fueled the reluctance of people from Crimea to study in Ukrainian. In 2014, the Ukrainian Ministry of Education did not recognize the school-leaving certificates issued by schools in Crimea. Crimeans were therefore not able to study in Ukrainian universities. So it's not Russia that is removing the means to study Ukrainian, but Ukraine which is distancing itself from the students and pupils in Crimea who are studying Ukrainian. Having experienced so many such measures on the part of Ukraine, the interest of families to study Russian and the lack of demand for Ukrainian is perfectly understandable. Schools in Crimea host dozens of events promoting the language, Ukrainian culture and language, and this goes against any misleading statements made by Ukraine to the effect or relating to the erasure of Ukrainian culture and education. Let me come back to the Albanian schools mentioned that Ukraine has relied heavily in this case. This holding is directly applicable to this case, where equal access to Russian language education discriminates against Crimean Tatar and ethnic Ukrainians. In fact, that is the quote of a statement made by Ukraine. But that assertion is entirely wrong. The Russian Federation has shown that it is not discriminatory in Crimea. Not only have we education in Russian, but also in Crimean Tatar and Ukrainian, which are both official languages in the Republic of Crimea. And on Monday, we had no coherent response by Ukraine on this issue. We have shown that there is no analogy between the facts here and the Albanian schools case. Ukraine seems to have found an analogy, and on Monday they stated that as recently as May 2023, just last month, Russia reinforced the discriminatory effect of its educational measures by seizing and looting the last remnants of the Orthodox Church of Ukraine in Crimea, an institution whose private schools has long been seen as a mainstay of Ukrainian language teaching and culture in Crimea. Now, there was no evidence, not even a footnote put forward by Ukraine relating to this event. Quite clearly, the court cannot rely on such facts to find that racial discrimination has occurred. In fact, Ukraine has not established a discrimination, let alone a discriminatory campaign or an educational erasure of Ukrainians and Crimean Tatars. This shows that the allegations of Ukraine relating to education as a violation of CERD is unsubstantiated. Which brings me to my third point, Madam President, the enforcement and application of the law. On Monday, Ukraine went on stating that the Russian Federation had armed law enforcement against ethnic minorities. But Ukraine has still not been able, and hasn't done it since the beginning of the proceedings, to refute the simple fact according to which law enforcement measures were taken by Russia not on ethnicity, but on the grounds of presumed criminal activity. As concerns police searches and detentions, for instance, the allegation of counsels for Ukraine seemed to be, on Monday, the simple claim that, and I quote, more than 70 Crimean Tatar individuals have been imprisoned based solely on their alleged association with alleged extremist organizations. Even though the sources referred to by Ukraine does suggest that this statement is questionable, it does, however, confirm the position of Russia since the very beginning, that these repressive measures have been taken on the grounds of association with violent and extremist organizations, not on the ethnicity of individuals. The case of Mr. Server Mustafayev, a Crimean Tatar currently in prison for his involvement with Hizb ut-Tahrir, an extremist organization, is one example. Counsel for Ukraine have not denied that Mr. Mustafayev had links with the organization, an organization whose declared aim is the establishment of an Islamic caliphate and the enforcement of Sharia law across the world, and which has been banned in Russia since 2003. The court must also know that this organization has been banned in other states, and that this approach has been confirmed by the European Court of Human Rights. In fact, Ukraine is suggesting that to the courts that Russia is not entitled to identify threats to national security and to act accordingly. Ukraine also maintains that a government cannot tackle violence and extremist threat when individuals involved can be said to belong to a specific ethnic group. This argument is not just clearly erroneous here, as my colleague has shown. It is also particularly dangerous if it were to be given a broader application in international law. And that's an argument that states would never have agreed to when becoming parties to the Convention on Elimination of all forms of racial discrimination.
Madame et Monsieur de la Cour.
Madam President, distinguished members of the Court, other individuals which Counsel for Ukraine sought to dwell upon yet again on Monday are those regarding purported disappearances, kidnappings, murders and torture. But these instances equally exemplify the fundamental weakness of Ukraine's arguments. For example, Mr. Gimblet stated that the purported kidnapping and murder of Mr. Shadamatov was a discriminatory act. Yet the Ukrainian authorities themselves, as we explained in our rejoinder, determined that Mr. Matov's death, in accordance with Ukrainian criminal law, was an intentional murder of a kidnapped individual and not an intentional murder motivated by racial, national or religious intolerance. For its part, the Russian Federation, which was in no manner implicated in the kidnapping of and murder of Mr. Amitov, made huge efforts to investigate this crime. As we explained in our memorials, Ukraine itself recognized that more than 270 witnesses were questioned by the Russian authorities, and that more than 50 forensic analyses and 50 examinations were conducted. Besides, Ukraine itself refused a request for legal assistance lodged by the Russian authorities in charge of the investigation. into this incident, but it had the temerity to criticize Russia in this great Hall of Justice for the way in which it conducted the investigation. Let us not forget that Council for Ukraine recognized again on Monday that the court may have some difficulty in attributing these disappearances to Russia. It is also revealing that Mr. Gimblett only made one general reference to the attribution under Article 8 of the Articles on State Responsibility, without in any way mentioning Russia's arguments, which demonstrate that the criteria set out in that article can clearly not be satisfied in the case before us. Furthermore, Ukraine has not claimed Russia played the slightest part in the purported kidnapping of Mr. Chenkun, a Euromaidan militant. Yet again, we have shown in detail that Russia conducted an in-depth investigation into that case, even if the alleged events occurred before the reunification of Crimea with Russia. In addition, Ukraine has sought to rely on the witness statement of Bishop Klimet, the Metropolitan of Simferopol and Crimea. But that statement does not suggest that Mr. Chenkun was kidnapped because of his ethnicity. Yet again, we see that although Ukraine has accused Russia of distortion and diversion in these proceedings, these terms can in fact only apply to Ukraine's allegations regarding this incident and others, and the manner in which it artificially brought the incident case before you. Might I add that Mr. Chenkun, according to social media, is alive and well and living in Kiev. Madam President, distinguished members of the Court, upon closer scrutiny, it appears quite clearly that with regard to allegations of disappearances, murders, kidnappings and torture, Ukraine has not been able to prove the existence of numerous illustrative acts. It certainly was not able to prove that these purported acts are evidence of a pattern of behavior or a concerted campaign against the ethnic communities of Crimea. Monday, Professor Koh rather strikingly declared that Russia conceded or silently recognized most of these facts, which underlie Ukraine's allegations of CERD violations. Needless to say, nothing could be further from the truth. Ukraine's assertion is unfortunately just one example of the hyperbole and manipulation which have characterized Ukraine's arguments since the very beginning of this case. Ukraine seems to hope that such arguments will be upheld by your court. The Russian Federation hopes, and indeed declares, that international law should definitely be taken more seriously than that. Madam President, distinguished members of the Court, this brings me finally to the last part of my presentation. Madam President, distinguished members of the Court, I would like to come to Ukraine's allegation according to which the Russian Federation did not abide by the court's order on provisional measures delivered in April, 19th of April 2017. According to Ukraine, the Russian Federation has breached the three measures indicated by the court. But I've just shown that the sweeping allegation of Ukraine regarding education must be rejected by the court. Equally, Ukraine's claim regarding a breach of the court's order must be rejected. Regarding the purported violation regarding the aggravation of the dispute contained in the court's order, I would like to say words about this, and this will conclude my presentation. Ukraine has emphasized events which took place as of February 1922, But this bears no relationship whatever with the present proceedings. In your 19th April 2017 order, you said expressly that the case of which the court is seized is of limited scope. Besides, Ukraine itself has brought a separate case before the court regarding the events which occurred as of February 2022, invoking the Convention of the Prevention and the Suppression of the Crime of Genocide. Whereas Ukraine has described Russia's conduct as making more difficult the settling of the dispute before you, it is a fact that the Russian Federation has actively sought a negotiated settlement between the parties in this case. In its response, Ukraine has called this proposal inappropriate. We had to remind it that in our rejoinder, the court itself, which the court itself has said, and pending a decision of the court on the merits, any negotiation between the parties with view to achieving a direct and amicable settlement is to be welcomed, quote unquote. Madam President, distinguished members of the court, I can but repeat that the Russian Federation has taken significant measures at all levels of its administration to comply with your order. The allegation according which the order has not been respected cannot simply cannot be upheld. And this brings me to the end of my submission. I thank you for your kind attention, and I would ask you, Madam President, to give the floor to Maître Jean-Charles Chikaya. Thank you.
I thank Professor Azari, and I now invite Professor Chikaya to address the court. You have the floor, Professor.
Madam President, I'd like to thank you because I stand before this court once again once we've gone beyond the allotted speaking time for Russia. I shall keep it short. That's the least I can do, you'll probably say, because there's nothing significant that's been said by our opponents as regards the section I'll be dealing with here. In other words, the question of citizenship, media, public events and cultural heritage. First of all, we'll see that Council for Ukraine tried to differentiate between this case and that of Qatar versus the United Arab Emirates and said, and I quote, that that case concerned a distinct legal question, namely whether discrimination based on a person's current nationality falls within the prohibition of racial discrimination within the meaning of the Convention. It did not address the discriminatory downstream effects of a forced citizenship regime on a third protected group, the issue appropriately before this court. End of quotation. Now, this description of the question, which I should say was dealt with in the 2021 judgment, is wrong. Aside from the question mentioned by Ukraine, the court ruled on whether the measures qualified by Qatar as indirect discrimination directed at Qatari citizens falls within the scope of the Convention. This question is clearly similar to the question of deciding whether the alleged downstream effects of a given citizenship regime on a third protected group fall within the scope of the Convention. Such effects, as stated very clearly by the court, cannot be based on a proscribed distinction. Rather, they would stem from a differentiation made on the basis of citizenship, which is not provided for by CERD as a forbidden basis for distinction or exclusion. Clearly, the goal of Ukraine is to use the term downstream effects in order to describe what is an actual fact, collateral or secondary effect. In this context, the judgment in Qatar versus United Arab Emirates cannot be separated from the question before you today, and there is no need to deviate from jurisprudence. Secondly, Ukraine continues to use the term forced citizenship in order to describe the citizenship regime applicable in Crimea without giving any answer in response to our arguments on that matter. It should be said once again that in no way is that regime forced. On the contrary, it is compatible, as has already been explained by Russia, with that provided for by the European Convention on Nationality and the Articles of the International Law Commission, and also the recommended approach by the United Nations General Assembly addressed to all states. On this matter, I would, with all due respect, refer you to the written submissions in paragraphs 410 to 424 of our rejoinder for further detail. Thirdly, Ukraine did not mention citizenship in its final conclusions. And here I'd like to refer to the court's decision in the asylum case, and I quote, "One must bear in mind the principle that it is the duty of the court not only to reply to the questions as stated in the final submissions of the parties, but also to abstain from deciding points not included in those submissions." End of quotation. If Ukraine's conclusions are not sufficiently precise as to the question of citizenship, they cannot be the basis for any application or claim for remedy. Now, on the media, we see that Ukraine continues to ignore all evidence submitted by Russia. Instead of responding seriously, Ukraine continues to repeat empty slogans devoid of any credible justification. Russia has demonstrated in its written submissions that there are at least 65 media outlets in Crimea working in the Tatar and Ukrainian languages. Ukraine has been unable to challenge or disprove that simple fact. But Council for Ukraine attempted to target a TV channel Millet, describing it as a propaganda tool allegedly created by the Russian Federation to replace the independent Tatar media. That is absolutely false. There is no censorship or propaganda on the Millet channel, as has been confirmed by one of its former employees. We would respectfully invite you to refer to paragraph 1191 to paragraph 1195 of the rejoinder, and also Annex 498 of the counter memorial, where you will find detailed information concerning the Millet TV programs. Ukraine's argument is in fact limited to the fact that Millet receives financing from Russia. But it should be underscored that the only Tatar channel in Ukraine, ATR TV, that Ukraine contrasts with Millet is financed by the Ukrainian government. And when the financing of ATR 25 came to a halt in 2021, the channel stopped broadcasting.
Which brings me to public events. Ukraine is still going on and doing the same thing, namely ignoring the evidence submitted by Russia that shows conclusively that there is no differentiated treatment against specific ethnic groups. Ukraine has not disputed that a number of public events has been successfully organized by the Tatar and Ukrainian communities, including Surgun and the celebration of the birthday of Taras Shevchenko. In its statement on Monday, Council for Ukraine strangely stated that Ukraine had decided to supply comparators to establish racial discrimination where, and I quote, "it makes sense to do so," end quote, while referring to the organization of public events. But Ukraine has, in fact, not referred to any comparators, showing that Russia treated the Tatar and Ukrainian communities differently on such public events. As concerns public events banned in the past, the only reason for that was that the organisers had not complied with the administrative rules set by local authorities, and no measure clearly was taken on the grounds of ethnicity, the ethnicity of organisers. Lastly, as concerns cultural heritage, there again, there is no response on the part of Ukraine. Russia, for instance, has chosen to show the court pictures of a number of cultural events freely being held in Crimea by way of illustration. But in those instances, Ukraine has only seen these pictures and seen in those pictures a Russian flag as the backdrop. Just to, in a way, express its own obsession. I'm sure that Ukraine will excuse me for showing this once again. you can see that those celebrate the birthday of Taras Shevchenko, the great author. So this clearly illustrates that these celebrations are still happening in Crimea, without any restriction imposed by the Russian authorities. And as you can see, it's not only the Ukrainians that are celebrating this, but also Crimeans of Russian descent, which pay tribute to this great poet. And if you, with your leave, Madam President, and with the leave of Russia, I will finish with a quote. I'll softly pray that God may grant to us that all the Slavs may brothers be. Madam President, ladies and gentlemen of the court, thank you for your attention. Can I respectfully request that you give the floor to the agent of Russia, His Excellency, Mr. Alexander Shulgin, to read out the Russian Federation's final conclusions. Thank you.
Professor Chikaya, and I now give the floor to His Excellency Mr. Alexander Shulgin, the agent of the Russian Federation. You have the floor, Excellency.
Madam President, members of the court, it's an honor for me to conclude the presentation of Russia's position and deliver its final submission. We have listened to Ukrainians' extensive oral pleadings, and we have been exchanging procedural papers in this case for 6 years. Now, it is more than obvious that Ukraine decided to misuse two important multilateral conventions, the ICSFT and the CERD, for its own political purposes. On the basis of the ICSFT, Ukraine seeks to brand the people of Donbas as terrorists, and the DPR and the LPR as terrorist organizations. In support, it basically relies on several selling incidents taken out of the context of the bloody armed conflict which Kiev has unleashed and pursued for all these years. Ukraine wants you to forget that it shelled and bombed the people of Donbas. It wishes you to forget that people of Donbas for years were subjected to blockade that brought them to the brink of the survival. Ukraine also seeks to exploit the tragedy of MH17. Moreover, in support of its allegations, Ukraine relies on fake evidence and threatens those who reveal the deceit. According to Ukraine, Russia somehow had an obligation to cooperate on the basis of speculative allegations that are supported by no one and cannot be proven to be terrorism even after 6 years of legal proceedings before this court. Ukraine devised this narrative in order to justify its war against Donbas, its violations and subsequent rejection of the Minsk agreements that led to the current armed conflict. Now it seeks to have this court's decision behind these heinous actions. Ukraine also attempts to misuse the CERD in order to accuse Russia of a fictitious apartheid-like regime in Crimea. The only support it has are just big, empty words regarding, I quote, tens of thousands of victims, unquote, and statements of extremists that have engaged in water, energy, and trade blockade of Crimea. Extremists that are rejected by their own people in Crimea, who call them traitors. Ukraine has the audacity to request this court to install these extremists and their organization as a representative organ of Crimean Tatars in Crimea. They seek to have this court's decision behind Mr. Chubarov, who threatens Crimean Tatars from this very courtroom. Ukraine has hypocritically requested court's protection on behalf of people of Donbas and Crimea. But these people do not need and have not asked for Ukraine's protection. They have chosen different destiny. What Ukraine means by that protection is more than evident from misanthropic statements of its high-level officials and blatant armed attacks. It is also clear that Ukraine has pursued these proceedings in order to distract world's attention from its own dealings, its state support for Nazi organizations and leaders, its suppression of Russian language and culture, as well as disdain for any other ethnic minorities. Ukraine came to this court with dirty and bloody hands. Ukraine uses this courtroom in order to project its false narratives. In its imagination, it has already won this case. Its submissions take the form of orders to this court and international community. However, Russia believes that this court will see the reality beyond the maze of artificial arguments and misrepresentation of facts, beyond pressure and myriads of political decisions. This is, at the end of the day, the role of chief judicial organ of the United Nations. Madam President, distinguished members of the court, in conclusion, I present to you the final submissions of the Russian Federation. For the reasons explained in its written submissions and developed further during the oral hearings, and for any other reasons that the court may deem appropriate, the Russian Federation respectfully requests the court, first, to dismiss all the claims that Ukraine made under the International Convention for the Suppression of the Financing of Terrorism, and second, to dismiss all the claims that Ukraine made under the International Convention on the elimination of all forms of racial discrimination. Madam President, distinguished members of the court, I thank you for your kind attention. I would also like to take the opportunity to thank all members of the registry and interpreters for their dedicated work throughout the hearings. This concludes the oral argument of the Russian Federation. Thank you.
I thank the agent of the Russian Federation. The court takes note of the final submissions that you have just read out on behalf of your government. This brings us to the end of the hearings in the case concerning application of the International Convention for the Suppression of the Financing of Terrorism and of the International Convention on the Elimination of All Forms of Racial Discrimination, Ukraine versus Russian Federation. I thank the representatives of the two parties for the assistance they have given the court by their presentations in the course of these hearings. In accordance with practice, I shall request the agents of the parties to remain at the court's disposal to provide any additional information it may require. The court will now retire for deliberation. The agents of the parties will be advised in due course as to the date on which the court will deliver its judgment. As the court has no other business before it, the sitting is now closed.